Fifth case from daily list item 8, second appeal 33 of 2023.
It is plaintiff's second appeal against judgment of adjournment. Plaintiff has filed a suit for declaration of his right title interest on the basis of the sale deed dated 28/8/1990.
1990.
1990.
90.
Yes, ma'am. And the sale deed number is 9106
9106.
along with the recovery of possession. And another player one, that is sale deed number 7043 of 1983.
7043 of 1983.
Be declared as null and void, which is in favor of defendant number 2 and 3.
This is in the name of defendant number 2 and 3.
2 and 3 are contesting the case only. Defendant number 4 is a housing society. One Krishna Nayak, defendant number 1.
Defendant number, just a minute. 2 and 3. Defendant number 4 is housing society.
Defendant number 1 Krishna Nayak has a vast piece of land which he has sold to society, and society was mutated.
Who are the vendors of these two sale deeds?
Society,
Who are the vendors?
Society.
Society is the vendor of both the sale deeds?
No. Sale deed of plaintiff. And prior to the execution of the sale deeds in favor of defendant number 4, he had executed the sale deed in 1983 in favor of defendant number 2 and 3. That is for which relief or cancellation has been sought for.
So defendant number 2 and 3 acquired the title over the property prior to
Yes.
its transfer to defendant
Yes.
number 4 by defendant number 1.
This is the finding of both the courts.
Then तो फिर क्या बचा?
हम तो कल फैक्ट बता के कोर्ट में
लिखिए. Essay number 33 of 2023. This appeal has been filed against the judgment dated 29/11/2022 within bracket decree signed on 6/12/2022, passed by learned Additional Judicial Commissioner Roman 18, Ranchi in civil appeal number 8 of 2019, whereby the appeal being title appeal number 8 of 2019, filed by the plaintiff appellant, has been dismissed. The trial court judgment is dated 12/10/2018 within bracket decree signed on 22/11/2018 bracket use, passed by learned civil judge junior division within bracket additional municip first bracket close Ranchi in original suit within bracket title suit number 35 of 2005. The learned counsel for the appellant who was the plaintiff before the court, has submitted that the plaintiff is claiming the property by virtue, the sued property by virtue of registered sale deed number 9106 dated 1/9/1990, and was also seeking recovery of possession. He submits that the claim of the plaintiff having been based on registered sale deed, both the courts have not properly considered the evidences on record while dismissing the suit. The learned counsel has submitted that the appellate court has also not properly considered the materials on record while confirming the judgment passed by the learned client. During the course of arguments,
The only objection we had, that none of the courts have taken care of relief number 2, that is regarding no issue framed, regarding cancellation, which has been challenged on the ground that it is forged and fabricated. But issue के बारे में अभी second appellate stage में तो कुछ बोल नहीं सकते.
the learned counsel for the appellant has submitted that a prayer was also made seeking cancellation of the earlier registered sale deed number 7043 of 1983, which was prayed to be declared null and void, but no proper issue was framed in connection with the said relief, and consequently both the courts have not considered one of the relief properly.
Oh, sorry. Issue has been framed as issue number 8. इसलिए वो पार्ट हटा दिया जाए. But
Okay, the learned counsel has submitted that the इसको ना no issue has been framed, इसको हटा देंगे. Has submitted that though issue has been framed, but the same has not been properly considered.
yes.
After hearing the learned counsel for the appellants and having gone through the impugned judgments, this court finds that the suit was filed seeking a declaration of right title interest in connection with the suit property said to have been purchased by registered deed number 9106, serial number 6979 dated 25/8/1990, and a prayer was also made that the plaintiff had acquired indefeasible right, title and interest in the suit land through adverse possession. An alternative prayer was also made by the plaintiff that if the plaintiff is not found in possession, a decree be passed for eviction of defendant number 2 and 3 and restore the possession to the plaintiff in the suit land. And defendant number 2 and 3 be directed to remove all constructions raised over the suit land. A further relief was also prayed in the suit seeking a declaration that the sale deed registered in the office of District Sub-Registry Ranchi, being sale deed number 7043 dated 28/6/1993, executed by defendant number 1 in favor of defendant number 2 and 3, be cancelled and declared as null and void, and it be declared that the same does not affect the plaintiff's right, title, interest and possession in the suit land. A prayer was further made seeking permanent injunction against the defendants. The defendant, out of the 4 defendants, only defendant number 2 and 3 had filed written statement, and the case proceeded ex parte against defendant number 1 and 4. Defendant number 4 is the cooperative society. Cooperative Housing Society, and defendant number 1 was the recorded rayat of the property. The case of the defendants was that they had purchased 4.5 kattha of land along with house constructed thereon, which constituted the suit property by virtue of registered deed of sale dated 28/6/1983 from defendant number 1. And after purchase, they came in possession, and the property was also mutated in their name by mutation case number 560 R27/8889, and they were paying rent to the state. It was their specific case that the defendant number 2 and 3 having purchased the land from defendant number 1, therefore there was no occasion for the defendant number 1 to sell the same property to defendant number 4. It was also asserted that there was no cause of action to file the suit. The trial court framed as many as 9 issues, and both the plaintiff as well as the defendant number 2 and 3 led evidence, both oral and documentary, including the respective sale deeds. The defendant also produced the rent receipt and other documentary evidences, including electricity bills in connection with the construction over the suit property. The learned trial court recorded the admitted facts between the parties, and one such fact was that defendant number 1 was the owner of the land, and that defendant number 1 had sold numerous properties, the property to the defendant number 4 by virtue of 8 registered sale deed. The learned trial court considered the materials on record and found that the property of Khata number 1, plot number 370, total area 4.21 acres out of 4.8 decimal, being subplot number 370/24, was purchased by the defendant number 2 and 3. Was purchased by the plaintiff from defendant number it was a case of the plaintiff that ये जो description of property है ना, that the plaintiff had purchased the property from defendant number 4, the housing society, on 25/8/1990. And on the other hand, it was a specific case of defendant number 2 and 3 that they had purchased 4.5 kathas of land from defendant number 1 much before the purchase of land by defendant number 4. That is on 28/3/1990. 1983, and they came in possession and got their name mutated. And after construction of the house, they were residing on the property with their family. The learned trial court, after considering all the materials on record in the light of the and ultimately held that the sale deed executed by defendant number 4 in favor of the plaintiff was never acted upon, and defendant number 2 and 3 were the first purchasers of land while exhibit A, and they were in possession of the property. The learned trial court ultimately found that the defendants were the purchaser of the specific portion of the land mentioned in Exhibit A, while the plaintiff also purchased the land mentioned in his sale deed by Exhibit 1/2. The map attached with the sale deed of the plaintiff was not crystallized, that which portion of the land was purchased by the plaintiff, as there was no mention in the sale deed of the plaintiff that from which deed of the defendant number 4 he purchased and derived the title. The learned trial court ultimately held that the plaintiff, that defendant number 2 and 3 were certainly the first purchasers and their sale deed was acted upon. Consequently, the issue number 3 to 8 were decided against the plaintiff and in favor of defendant number 2 and 3. And while deciding issue number 1, 2 and 9, the learned court held that decided these issues against the plaintiff and against the plaintiff and in favor of the defendants and dismissed the suit. The learned appellate court also considered the materials on record, and the point for consideration was the points which were formulated by the learned trial court were also considered by the learned appellate court. ये अलग अलग पॉइंट फ्रेम किए ना पैरा पेज नंबर 12 से हाँ द पॉइंट्स वर फॉर्मुलेटेड एज अंडर इसको जरा क्लिक करेंगे ये 1 पेज नंबर 12 एपिलेट कोर्ट का जजमेंट 2 and 4 then 3 5 सेम इश्यूज है कि अलग अलग इश्यूज Same issues were considered.
Issue wise deal क्या है?
The appellate court has considered the appeal issue wise on the same issues which were framed by the learned trial court. The appellate court has also given concurrent findings after considering the materials on record and clearly held that defendants had acquired the right title, interest and possession over the disputed property. And dismiss the appeal. This court finds that there are concurrent findings recorded by both the courts who have recorded clear finding in favor of the defendant number 2 and 3 that they acquired the property by virtue of previous registered sale deed, and they were also in possession of the suit property. Considering the aforesaid facts and circumstances, no question of law, no substantial question of law is involved in this case, which is hereby dismissed. अपना appearance दे देंगे सर.
For final disposal, item 1, second appeal 50 of 2016.
The appellants of the plaintiff, it's page 25. The net trial court judgment.
Concurrent findings.
Yes, sir. So concurrent finding, but in this matter, also the suit has been decreed in favor of the petition, this appellant. To partly it was partly allowed by the net trial court and led by the appellate court.
Partly decreed
Partly decreed.
and appellate court.
The same has remained.
Appeal dismissed.
Appeal was allowed to some extent. That's what I'm just saying. Some
Whose
more
appeal
issues
was
were.
allowed? If it was partly decreed, whose appeal was allowed?
My appeal was allowed.
You are who?
I was the plaintiff.
Plaintiff. Plaintiff's appeal partly allowed.
Partly.
तो क्या बचे?
Let's say in this case, one thing has remained. The right title and interest of the plaintiff has not been declared. This particular order was not passed. And the issue which has been framed in this case, let me again see. Order dated 13/5/2024. Order number 12.
Not been declared.
What's it?
What was the relief?
The
What was the relief prayed for?
relief was paid for declaring right title and interest. of
Let
the
us see the
petition.
judgment. Decree
Page
दिखाइए.
25.
पहले decree दिखाइए.
Page 33. Merit. A decree declaring the plaintiff's subsisting title in the suit land, holding that recording of the suit land in the name of defendant is wrong and erroneous, for the confirmation of the possession of the suit land. In alternative, recording the possession of the plaintiff are dispossessed in the meantime for permanent injunction restraining the defendant.
Why
of
subsisting title in the suit line?
Because the title was still subsisting, but the thing has been, it has been said that this particular suit land is not entirely in the favor, entirely in the on the land of the plaintiff. This has been said. It was big. This is not the defendant that has come, but it has come that this suit land is exclusively not of the this appellant. This is. Third prize for permanent injunction restraining the defendant from interfering in the possession of the plaintiff on the suit land. This was declared in our case.
Permanent injunction.
Yes, sir.
So you got a relief only of permanent
Permanent
injunction.
injunction. The relief C has been only given.
Let us see the title suit.
Page 25. Merit.
Yes.
This suit is filed by the plaintiff against the defendants for declaring the subsisting title confirmation of possession in a alternatively for recovery of possession and for injunction, and also for holding that recording of the suit land in the name of defendant is wrong and erroneous. According to schedule of the plaint, the suit land situated at village Baragamriya, PS Adityapur, district Singhu, recorded in 1964 survey under Khata number 515, plot number 460/A, southern side, area 1¼ decimal, bounded on north portion of 460 old, south 458 old. Corresponding to 1983 survey Khata number 165, lot number 346, small a, ward number 1, area 0.0050 hectares equals to 1¼ decimal. Bounded on north 342 of plaintiff, south 346B of defendant, east 345A of Srivas Kumar Paul, plaintiff, west Rasta. The case of the plaintiff, the government of Bihar carried out survey operations under CNT Act, and the recording of right was prepared. Records of right was prepared and published in September 1964, in which the landed property of the plaintiff were recorded in Khata number 550 of village Baragamria, consisting of several plots, including plot number 460, which is the plaintiff's possession as the joint lands. The
As
village,
the joint lands, matlab?
there are several appellants. They are holding joint possession of it. The village Baragamria has later included in the NAC Adityapur, and plaintiffs submitted that the small portion of plot number 460 of 1964 survey was wrongly plotted as new plot number
Just a
346.
moment, इसका पिन निकाल लीजिए, इसका स्टेपलर निकाल दीजिए.
A portion of plot number 460 of 1964 survey was wrongly plotted as new plot number 346A with an area of 1¼ decimal in Khata number 165 of ward number 2 in the name of the defendants in the NSC survey of 1983, the record of which was published on 15/2/82. It has been stated out of total area 57 decimal of plot number 460, 18 decimal was acquired by the government in road, and 7 decimal was sold to the Bimal Agrawal, who in turn sold to the Narayan Agrawal. The rest land, that is 32 decimal, is with the plaintiff. The plaintiffs have claimed that the suit plot 346A is part and parcel of plot number 460 of Khata number 550 of 1964 survey of the plaintiff. It has been further stated that the defendant was son-in-law of the Mukhia family, from whom he got on 3 decimal of land, where he constructed mud-built Khaprel house. He has a pakodi shop and a gully to go into and to come out of the main road, which run west of the land, measuring 3 decimal, and the area of 3 decimal only was recorded in the name of defendant in Khata number 100 of 1964 survey, consisting of mud-built house with Khaprel title, Khaprel tiles, which as alleged in the northern side of the house of the Sasural of defendant. The Sasural of defendant had also given some land to Sisumati, the Sali of defendant, and Sisumati held the land with her house therein, which was plot number 461 in 1964 survey. This plot number 461 of Sisumati was recorded as new plot number 345A, 345B, 345C, which she sold to the plaintiff Srivas Paul, who has constructed a building for UCO Bank in portion of plot number 460, and the above purchased land from Sisumati. The bank staff have their residence also there, and plaintiff had laid a water pipe along the suit land, which also serves as passage from the bank building, and a door is maintained from the bank through which the plaintiff uses a passage. The plaintiff were not aware of wrong recording, and for the first time in January 1994, while the plaintiff were planning to make some construction. The defendant claimed that the suit plot number 346A belonged to him and the same is recorded in his name in khata number 165 of ward number 11 NAC Adityapur, and hence he should not allow the plaintiff to use the suitlet as passage, hence the suit was filed.
So basically the passage is in
Yes.
this. Passage पे आप अपना exclusive right कैसे declare करें?
It has been held that this suit was exclusively possessed by this plaintiff.
This is easementary right.
The plaintiff,
Easementary right exclusive right नहीं होता.
this passage is not for the defendant to go to their houses. This was a passage which has been created by the plaintiff itself for the purpose of giving go through to the bank staffs and the bank which has been in my.
So it is being used for easement, isn't it? Plaintiff has given this
Yes,
for easement
yes.
and it is being used for by the public. जैसे कि कोई अगर नाली के लिए कोई जगह छोड़ दे,
जी।
right? उसी तरह से कोई पैसेज के लिए जगह छोड़ दे.
नहीं,
तो exclusive possession कैसे declare?
ये जो गली जो दिखा रहे हैं 114 कट्ठा का ये डिस्मिल का ये गली सिर्फ मेरे ही घर के लिए यूज हो रहा है और किसी के लिए यूज नहीं हो रहा
ऐसा तो नहीं लग रहा है यहाँ से.
है. वो है इनका खुद ही का स्टेटमेंट, इनका खुद का एडमिशन है. That is
Finding of fact is there that it is being used by both the parties.
दिखा रहे हैं.
Let's just see, एक second रुक जाइए. आगे पढ़िए.
The defendant case is brief that the plot number 462, khata number 100 of Mauja Bara Gamaria was recorded as Makan Sahan in the name of defendant in 1964 survey, and the same has been reported as plot number 345A, B, C, and D in the Adityapur NAC survey of 1983, which exclusively belonged to the defendant, and he is in actual physical possession of the same. The defendant has also challenged the maintainability and cause of action of the suit and stated that the suit is barred under Article 113, 64, 65 of the Limitation Act, as well as under the SR Act, and hence liable to be dismissed. On the basis of pleading, following issues were framed. First, whether the suit is maintainable in its present form and for the relief claim. Two, whether the plaintiff has got any cause of action to file the present suit against the defendant. Whether the suit is barred by provisions of specific relief act. Whether the suit is barred by Article 115 and 65 of the Limitation Act. Whether the suit is barred by the principle of waiver, estoppel and acquiescence. Whether the suit property is grossly undervalued. Whether the present suit is not part and parcel of old plot number 460. Whether the suit land is exclusively belong to the plaintiff or it belong to the defendant. Whether the plaintiffs have got any manner of right, title and interest and possession over the suit land, or the suit land is the rayati property of the defendant. Whether the plaintiff used to possess any part of the suit land as gali rasta. Whether the plaintiff are entitled to get any relief or reliefs claim in the suit. To prove this case, the plaintiffs have examined 9 witnesses and exhibited 19 documents. Out of above 9 witnesses, PW5 Basant Kumar Paul, 50 years, is the plaintiff number 3 himself.
Now you come to the finding.
Yes. What's it, page 4? Last 3 paragraphs. Issue number 6 has already been declared
वो तो
on
पहले ही हो गया.
जी.
आपको कोर्ट केस वाला कहानी.
second 3 and 2 5 that has not been considered, but उस पर कोई order pass नहीं किया. These issues
Not
have
being
not been
considered
raised
मतलब
by
पढ़िए.
these issues were raised by the defendant. That was not said.
Just a moment. आगे पढ़िए. By the
हाँ.
defendant. Ornamentally.
These issues have been raised by the
Ornamentally.
defendant.
But no
ornamentally
evidence has been advanced to prove the same and remain not proved.
proved.
Hence decided accordingly.
Yes, it was raised
You are
by
the defendant.
No, he was the defendant. I was
So
the plaintiff.
you are not agreed by 3 to 5.
Issue number 7 to 10 and 11. This is the issue. Yes.
Yes, please.
These issues so much connected to each other that decision on any of the issue requires the discussion of other also have taken together. Exhibit B and Exhibit 6/2 are same. On the perusal of it, I find these facts. Plot number 462, area 3 decimal, has been recorded as Makan and Sahan in the khata number 100 of defendant Gopal Banerjee of Mauja Bada Gamaria, 1964 survey. Second, on the scrutiny of Exhibit B and 6 both are the same. It is clear that plot number 346A, B, C and D of Khata number 165, area number such and such, has been recorded in the name of Gopal Banerjee in the 1983 survey of Adityapur NAC ward number 11. Baragamaria plot number 345B and D have been recorded as Makan Kacha Khapara Post and plot number 345C as Angan, but the plot number 345A has been recorded as Gali. On the comparison of above two recording, I found that in 1964, old plot number 462, Khata number 100, has an area of 01.20 hectare only, which was recorded in the name of Gopal Banerjee, whereas in 1983 survey, the Khata number 165 total area of plot number 345A, B, C and D is total is 2.35 hectares, which is double to that of previous. This clearly proves that an extra area of 0.01.15 hectare has been recorded in the name of Gopal Banerjee. On the basis of admission of the DW7, the defendant himself, in para number 11, 12 and 13, it is clear that defendant has got only 3 decimal of land of plot number 462, 1964 survey, from his Sasural, 3 decimal, but in 1983 NAC survey, 2.35 hectare land has been recorded in the name of Gopal Banerjee. In the meantime, the defendant has not acquired any other land, hence extra land is certainly being encroached, has been encroached of another plots. Exhibit 5 is the original survey map of 1964 survey of village Baragamaria, and Exhibit 4/4 is the trace map of disputed plot prepared by the survey nomenclature commissioner. On the joint study of it, I found that the plot number 460 and 462 is separated by plot number 461. DW7 defendant himself has admitted in para 18 that वादी लोगों का प्लॉट नंबर 460 बपौती संपत्ति है, प्लॉट नंबर 460 एवं 461 पर मेरा कोई हक नहीं है, उस प्लॉट पर वादी लोगों का हक है. On the study of Pleader Commissioner's report, I found that he has reported at the page number 3 para of Exhibit 4/1. On measurement, I found that the plot number 346A of Khata number 165 of ward number 11, NAC Adityapur, is part and parcel of an area measuring 0.00.30 hectare, plot number 460 of Khata number 4515 of Moja Baragamaria, bracket 1964 survey, and plot number 461, an area measuring 0.00.20 hectare of same survey. No part of 346A has been amalgamated with RS plot number 462 of Khata number 100. The above report has not been challenged by the defendant, hence deemed to be accepted. In para 4 of his deposition, the Pleader Commissioner has confirmed that above fact, and the same fact has also been confirmed by the Pleader Commissioner during his cross-examination in para 10 of his deposition. On comparison of Exhibit 5 1964 survey map with Exhibit 5/1 1983 survey map, and similarly on comparison of 3 maps, Exhibit 4/3 with Exhibit 4/4, is clear from the open eye that plot number 346A, area 0.50 hectare, that is 1 1/4 decimal, is not the part of plot number 462 of 1983 survey. The suit land plot number 346A is recorded as Gully. Plaintiff and defendant both sides have deposed that it is Gully. The survey knowing Pleader Commissioner PW9 has also accepted that the suit plot is Gully in para number 9. This plot has not been exclusively carved out from the plot number 460 of 1964 survey. And this fact is also clearly proved from the survey map and trace map, Exhibit 5, 5/1, 4/3 and 4/4, and hence the claim of the plaintiff that they has exclusive right on the gully is also not based on the fact and documents, and hence oral evidence is discarded. The other documents produced on behalf of the plaintiff, Exhibit 1 by 5, 1 to 1 by 5, rate receipt, Exhibit 2, Exhibit D to A by 12, requires no considerations for the decision of this case, hence not discussed. On the perusal of Exhibit 3, it is clear that the plaintiff Srivas Paul has purchased the land of plot number 345A, B and C, area 00.02.30 hectare from Sisumati. On the perusal of deposition of PW5, para number 13 and 15, PW6, para 3, it is clear that on the above plots, a building has been constructed which has been rented to the UCO Bank. On the perusal of the entire oral evidence, it is clear that the plot number 346 is being used as gully only, PW5, para 15. Exhibit 6 by 3, the CC of Khata number 515, wherein in the name of plaintiff, shows that the area of plot number 460 was 57 decimal in 1964 survey. Out of 57 decimal of plot number 460, 18 decimal land is acquired by the government in construction of Tata Khandra Road. This pleading was supported by PW5 in para 10. Out of rest 39 decimal, 7 decimal land has been sold to Bimal Agarwal, PW5 para 10, and rest 32 decimal is in possession of the plaintiff. The claim of the plaintiff is that new plot number 342 R 0.11.00 hectare, that is 27.5 decimal, has been carved out from plot number 460 of 1964 survey. This fact got its support from the comparative study of Exhibit 5 and 5 by 1, Survey map of 1964 survey and 1982 NSE survey, as well as from Exhibit 4 by 3 and 4 by 4 of the trace map prepared by the survey nomenclature commissioner. Hence, the claim of the plaintiff supported by oral evidence that raised 5.5 decimal amalgamated in 346A and other plots appear to be true and reliable. But as the report of the pleader commissioner shows that the entire plot number 346A is not carved out from plot number 460, and this fact also appears to be correct from the comparison of old map Exhibit 5 and trace map 4 by 4, which new map Exhibit 5 by 1 and new trace map Exhibit 4 by 8. So the above documentary evidence clearly proves that plot number 346A is being used as gully by the parties, and not part of it has been carved from the plot number 462 of 1964 survey, which belongs to the defendant. Hence, it does not belong to the defendant, and hence this is not the rayati property of the defendant. Again, the new plot number 346A is partly carved out from old plot number 460 and partly carved out from old plot number 461, and this shows that the suit land is not part and parcel of old plot number 460, and hence the suit land does not exclusively belong to the plaintiff, and hence they have no exclusive right to possess the same, but the plaintiff have every right to use and possess the suit land as gully and rasta, and the defendant has no right to interfere the plaintiff to use the suit land as gully and rasta, since no part of new plot number 346A has been carved out from old plot number 462, which thus touches old plot number 462, Exhibit 5. Hence, the recording of the suit land in the name of defendant is wrong and erroneous. In the light of above discussions, issue number 7, 8, 9 and 10 are decided accordingly, and plaintiff are entitled to the relief C only. This is in the result of their
The
order.
appeal was dismissed in totality. It was completely dismissed. Partly नहीं allow हुआ है आपका. गली है, and it is said that this property is portion of 460 and 461 दोनों का मिला था. It is under common use of both the parties. You have also admitted that it is being used commonly by both the parties. There are admissions on your part also. So ये substantial question of law बताइए क्या हम decide करें?
इसमें एक चीज बता दें.
According to you, confine yourself to the substantial question.
Yes. Substantial law is the which is
Sorry?
whether
Okay.
both the learned courts below have committed an error in not recording the right, title and interest over the suit property, despite the admission in pleading and evidence that the suit land was the ancestral property of the plaintiffs or defendants. Let's see what I'm saying.
Of the
There are 3
एक
plots.
सेकंड सूट लैंड वाज द ancestral property of the plaintiffs or the defendants का क्या मतलब है? You have common ancestor.
No.
Then इसका क्या मतलब है? बताइए.
Defendants.
ये क्या होना चाहिए था? आप फ्रेम कराए हैं, आप ही बताइएगा ना. क्योंकि उस समय तो रेस्पोंडेंट का कोई काम नहीं रहता है जब सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम. You see, the law is even if it is your property, गली यूज हो रहा है तो आप उसको डिस्टर्ब नहीं कर सकते.
नहीं, गली का वो नहीं करेगा. There are 3 plots. नर्सरी बता 3 plots. 460 मेरा है. Now 461 plot वो that belong to the Sisumati which has been purchased by the appellant number 4. Complete land has been purchased. Now the defendant's land is 462 and it has been held that this gully was not part and parcel of 462, rather it is a part parcel of 460 and 461. This has been said. That then this both land has been purchased by me. The 460 is already mine and 461 is has been purchased by the appellant number 4.
Well,
Yes, sir. This has come.
देखिए आप हमको एडमिशन
Yes,
दिखाइए
sir.
जो सब्सटेंशियल क्वेश्चन ऑफ लॉ. एडमिशन दिखाइए. By not declaring right title and interest over the suit, despite admission in the pleading. कौन सा admission है? कौन सा paragraph है pleading? पहले pleading दिखाइए.
Page 29.
नहीं pleading
The
तो
last
आप
paragraph.
pleading तो हम pleading से देखेंगे ना. आप बताइए कौन सा? रिकॉर्ड तो pleading देखने के लिए मंगाया गया ना.
DW7 paragraph number 18.
किसका रिटन स्टेटमेंट देखें?
DW7 का डिपोजिशन है paragraph 18.
डिपोजिशन नहीं. पहले एडमिशन एंड प्लीडिंग दिखाइए, उसके बाद डिपोजिशन देखिए.
Paragraph 19 I have denied.
पैराग्राफ 19 था प्लेंट का.
Written statement.
नहीं, दैट्स राइट. इनका कौन सा एडमिशन बताइए भाई. आप क्वेश्चन ऑफ लॉ फ्रेम कराएं, एडमिशन पॉइंट प्लेन दिखाइए. कौन सा पैराग्राफ देखें और कौन सा एडमिशन देखें. एविडेंस का एडमिशन बाद में, पहले प्लेन एंड रिटन स्टेटमेंट का एडमिशन देखें. बताइए, लीडिंग बताइए फिर एविडेंस देखेंगे.
Paragraph 23, they are saying it is that it may be mentioned here that the khata number 100 of Moja Paragamaria consists of plot number 462 was
नहीं,
recorded in the
पहले तो प्लेंटिफ का पैराग्राफ बताएंगे ना, तभी ना एडमिशन होगा. आपका प्लेंटिफ का पहले बताइए कि कौन सा पैराग्राफ का एडमिशन आपका रिटन स्टेटमेंट में आएगा.
So paragraph number 11 of plaint.
Yes, and corresponding para.
And corresponding para is paragraph number 21 of the WS.
20. Plain का para 11 करिए.
Para 11. That the village Baragamaria and certain other villages are included within the Adityapur notified area. The state of Bihar carried out the survey under CLT Act and section 19(1) of the B&O Municipal Survey Act, and the land bearing plot number 460 of 1964 survey concerned in the suit and other lands of the Baragamaria fell in ward number 11 of the Adityapur NSC. The area transfer from plot number 460 to the above named Narayan Das Agarwal was reported as plot number 341, and the remaining areas of plot number 460 belonging to the plaintiff were reported as plot number 342 measuring 0.1100 hectare as Sanjukt Dakhal of the plaintiff and recorded in khata number 1032 of ward number 11 of NSC Adityapur, and the small portion measuring 1¼ decimal equivalent to 0.0050 hectare, which was portion of old plot number 460 and kept as gully, is recorded wrongly in the name of defendant as plot number 346A. They simply answered this, that so far the statement made in paragraph number 10 and 11 of the plaint, the answering defendant begs to submit that those statements are made to confuse the mind of court and to mislead the court from proper appreciation of facts.
This is admission.
No, this what I'm saying.
जैसे क्वेश्चन ऑफ लॉ पे आइए, पहले एडमिशन इन प्लेंट देखेंगे फिर एडमिशन इन एविडेंस देखेंगे. प्लेंट में तो आप कुछ एडमिशन दिखा नहीं पाए.
They have denied.
So there is they were in dispute with each other. Admission तो कुछ नहीं.
As per the impugned judgment, we have seen, sorry, the
Impugned judgment नहीं, as per question of law. पहले आप pleadings पे एडमिशन दिखाइए, फिर एविडेंस पे एडमिशन दिखाइए. That this gully, as per the defendant, also was your property. नहीं है ना?
नहीं, ऐसा नहीं.
तो pleading में there is no admission. You have seen the plaint and written statement.
जी.
I'll take it then.
Yes, yes.
अब एविडेंस में एडमिशन दिखा. देखिए, यहाँ पे खड़ा होकर पढ़ना सही बात नहीं है. जब आपका प्लेन चार्ज, जब आपका यही इशू बना है तो आपको पता होना चाहिए ना कौन सा एविडेंस पे एडमिशन है. बताइए.
PW7, paragraph number 18.
PW7 is a defendant.
Sorry, DW7.
DW7 is a defendant.
Yes, defendant.
Para number
18.
18. पढ़िए. DW7 का para 18.
वादी लोग बड़ा गम्हरिया के पुराना बासिंदा है। वादी लोगों का प्लॉट नंबर 460 बपौती संपत्ति है। प्लॉट नंबर 460 एवं 461 पर मेरा कोई हक नहीं है। इस प्लॉट पर वादी लोगों का हक है।
Four 460 and 461.
जी
Plaintiffs have the right and not the defendant.
they are claiming 462.
These are the old plot.
Yes.
Defendants are claiming 460.
462 old plot.
Old plot. These are also old plot, 460 and 461.
Yes. Corresponding new plot may be permitted to say.
Hmm.
For 460 it is 346A.
Just a moment. 460 it is
46A
346A.
and for 461
Yes.
345A, B and C.
And C. And for 462, गली किसमें है?
गली इसी दोनों में हिट हुआ है, इसी दोनों में गली।
फाइंडिंग क्या है? गली किसमें है? दोनों में से? दोनों का पार्ट है।
दोनों का पार्ट 346A and 345A।
346A and 345A. So you say that since 345 and 346, no, 460 and 461 was belonging to the plaintiffs. Therefore, there was no impediment in declaring your right, title and interest in connection with lot number 4, in the gully.
Yes.
यही आपका केस। Did you claim that the suit land is part and parcel of only plot number 460? Or was it your claim that the suit land is part and parcel of 460 and also 460?
We have initially claimed that 346A is part and parcel of 460,
Yes.
and the finding is that it also contains some part of 461, which is the purchase
No,
by.
that is fine. You see, did you claim that the suit property is partly from 460 and partly from 460?
No,
No. You claim that the entire suit property is from 460.
460.
And the gully was found to be partly from 460 and partly from 460.
Yes,
Then how the entire gully could have been declared?
because the 460 and 461 is the property of appellant itself.
No. That was never your case. Your case was that your property, the suit property, was in plot number 460. It was never your case that it was in plot number 461. ऐसा तो लगता नहीं कि आपका केस
नहीं, वैसा केस नहीं.
तो वैसा केस नहीं है तो आपका गली कैसे आपका एक्सक्लूसिव प्रॉपर्टी डिक्लेयर हो जाएगा?
Because in pleading it has come, this property 345A, B and C that has been purchased by the appellant number 4, and appellant number 4, they are the Gotiyas of this appellant number 1, and they possess the same all this land in the joint possession. So this particular gully is on the land which belong to the appellants and not belong to the respondents. Because it has come कि 462 में ये जमीन है
462 में नहीं है।
जी.
डिपेंडेंट का लैकुना से आपको नहीं मिलेगा ना। आप हमको ये बताइए क्या आपका ये केस था कि 461 में भी है ये?
नहीं,
ऐसा तो आपने केस ही नहीं बनाया आपने। A gully has been found to be part of 460 as well as 461.
हाँ.
अब क्या हम डिसाइड करें बताइए? जो आपका केस ही नहीं था वो कैसे आपके बियॉन्ड द प्लेंट, बियॉन्ड द स्कोप ऑफ द सूट क्या डिसाइड करेंगे? और आपका तो यूज पर तो कोई दिक्कत ही नहीं किया
यूज
है,
में कहीं
यूज में कहीं कोई दिक्कत नहीं है।
यूज में टाइटल में भी दिक्कत नहीं है, यूज में भी दिक्कत नहीं है।
डिफेंडेंट का रिकॉर्डिंग भी गलत कर दिया है, जो रिकॉर्ड ऑफ राइट में जो एंट्री है वो भी गलत कर दिया है।
हाँ, because this 1 1/4 decimal has been shown in their name in the subsequent survey.
प्लेन दिखाइए तो। आपका सूट था फॉर a decree declaring that the plaintiff's subsisting title on the suit land, holding that recording of suit land in the name of defendant is wrong and erroneous. अब जैसे प्लॉट नंबर 460 पर क्लेम किया, you had no claim in connection with plot number 461. Rather, the description of the suit property was not correct because there was no reference to plot number 460. कोई reference नहीं था.
In
And the
pleading there
finding
is-
is that it is belonging, it is in 460 and 461, that गली. इसीलिए आपको पूरा suit property का exclusive right नहीं था. That is the reason. That is a specific case that the present suit is concerned with the plot number 460 of Khata number 515 of survey of 1964 containing an area of 0.57 decimal, recorded as Sanjukt Dakhal of the recorded owner of the painting. आपका concern ही नहीं था 461 से, and the gully is in 460 and 461.
But in pleading there is force with regard to 461. It is belong to the appellant side.
कहाँ है pleading में 461 का कोई कहानी?
मैं
आपका
मेरा
पूरा
plate-
प्रॉपर्टी का डिस्क्रिप्शन ही है ये 460.
हाँ.
हाँ. The entire case was relating to 460.
शेड्यूल प्रॉपर्टी तो 460 को
Sorry,
शेड्यूल प्रॉपर्टी तो 460 को ही लेके आए.
460 को लीजिए. तो जब गली दो पार्ट में है 460 एंड 461, तो आपका गली का जो डिस्क्रिप्शन है एज पर द फाइंडिंग, द गली इज द प्रॉपर्टी, the suit property is the gully. Gully has been found to be in 460 and 461 codes. तो आपका exclusive possession कैसे निकलेगा?
एक्सक्लूसिव पोजीशन तो होगा, बट वी हैव नॉट सेड कि ये 461 में भी आ रहा है. That we
नहीं,
have not
exclusive possession कैसे हो जाएगा?
said. 461 has been purchased by the applicant number 4. That has come. That
That's
is in the
right.
pleading.
461 might have been purchased. So on account of purchase of 461,
The entire suit property will come in my.
ऐसा आपका केस नहीं बना है ना.
हाँ, 460 ही हम लेके चले हैं वहाँ.
आप 460 ही लेके,
Scheduled property में
461 नहीं लेके चले. और कहाँ फाइंडिंग है that 461 has been purchased by
Yes.
applicant number 4?
Yes.
कौन सा डीड है? एग्जिबिट? एग्जिबिट दिखाइए.
Exhibit page 3. Exhibit 3. Exhibit 3. Exhibit 3.
रिटन स्टेटमेंट में है कि that the suit land is a part of 462,
Yes.
right?
Yes.
और ये किसका है 460?
460 belong to our ancestor.
नो नो, ये कौन सा सेल डीड है? आपने कहा 461 परचेज किया।
Yes,
कहाँ?
Exhibit 3.
हाँ, कहाँ है 461?
And the corresponding recording in the in judgment at page
नहीं नहीं,
7.
आप हमको ये डीड से दिखाइए, कहाँ है 461 इसमें लिखा?
461 345 A, B and C.
आप 461 दिखाइए ना।
461 in 1964 survey. Now in 1983 survey it is 345 A, B and C.
दैट्स राइट। तो इसमें कहाँ लिखा है 345 ए बी एन सी? टोटल एरिया आप ले रहे हैं उसका, ये सेल डीड में लिखा है कहीं? बताइए, बढ़िया है भाई, आप लोग रिकॉर्ड नहीं देखते हैं, इससे तो बहुत मुश्किल है। इतना सेकेंड अपील में ना रिकॉर्ड देखा नहीं जाता, ठीक है? इतना एप्रिसिएशन ऑफ एविडेंस नहीं होता सेकेंड अपील में, अनलेस यू शो इट एक्सपेशाई परवर्स, नहीं होगा। पूरा रिटन स्टेटमेंट में आपका 461 के बारे में कोई प्लीडिंग नहीं है, रिटन स्टेटमेंट में भी नहीं है, आपके में तो है ही नहीं।
ये मेरे में है।
आपके में 461 का कहाँ है? आपका सारा कहानी 460 का है।
हाँ, मेरा
तो फिर
सूट प्रॉपर्टी है वो हम लिख रहे हैं जो
but the finding is that the suit property in 460 and 461 both. You said that 461 was purchased by you. It is not there in your pleading also. And show me which document showed that the 461 was your
Yes.
property.
page which
बताइए।
बीच में है 346, 345A, 345B and 345C with their respective areas in the middle portion.
भाई आप इसमें 345A, B and C, इसका आपने लिखे हैं 345A एरिया दिस मच,
Yes.
345B एरिया दिस मच, 345C एरिया दिस मच। तो कैसे पता चलेगा कि पूरा प्रॉपर्टी आपने खरीदा हुआ है? And which portion of the property has been purchased? And there is no foundational pleading also to this effect. You have not made out a case that this gully is situated in 460 and 461.
हाँ, वो नहीं
You have made out a case that the gully is
460.
situated in 460. But during the evidence it has come, there is a finding that it is in 460 and 461. Now you say that the 461 entire plot also belongs to you. कहाँ से? उसमें 3 दिया हुआ है, ये शेड्यूल डिस्ट्रिक्ट सिंहभूम, इसका 0.80, इसका 0.20 हेक्टेयर एंड प्लॉट नंबर 345C।
जी
345C का एरिया है 1.20 हेक्टेयर। कहाँ लिखा है कि पूरा आप एरिया खरीदेंगे?
सिर्फ इसमें पेज 8 में आ जाए इनपिल ऑर्डर का, उसमें कहते हैं अगेन द न्यू प्लॉट नंबर 346A is partly carved from plot number 460 and partly carved from plot number 461.
आपको क्या बोलना है?
Entire case was based on plot number 460. Even issue was framed whether the suit land has been carved out from plot number 460 or not, which they have miserably failed to prove. Subsequently, even when they say that it has carved out from 460 and 461, they ought to have amended the pleading as has been held by the Honorable Supreme Court in a writing of decision. Even if fresh pleading or evidence come, it cannot be taken on record unless and until they filed an amendment petition. As far as Gully is concerned, it has come that that is being used by both the parties. So it is not within the exclusive possession of the plaintiff. And as far as right title interest is concerned, there a specific case was that suit land has been carved out from plot number 460, which they have misrepresented. 2-3 judgments. In the first one, paragraph 39. In the first judgment, paragraph 39.
Please can you read it? You have a copy?
It may be mentioned that in the plaint filed by the appellant, the plea setup was that at the instigation of the defendants and in collusion with them, the Mill Mazdoor Sabha has refused to give its permission to the sale of the mill premises of defendant number 1 to the plaintiff. It was not a case set up by the appellant that Mill Mazdoor Sabha had agreed to the proposed sale on certain conditions offered by the plaintiff. In view of the settled position of law, fresh pleadings and evidence which is in variation to the original pleadings cannot be taken unless the pleadings are incorporated by way of amendment of the pleadings.
Yes.
The next judgment is judgment of Sivaji Balaram, 2018, volume 11.
Just a minute. This is para 39.
39.
Yes.
Next judgment, 2018, volume 11, SCC 652. The relevant paragraph is paragraph 626,
Yes.
page number. Maybe.
Yes.
It is these issues which were gone into by the two courts and were concurrently decided by them against the respondent. These two issues, in our opinion, should have been examined by the High Court with the view to find out as to whether these findings contained any legal error so as to call for any interference in the second appeal. The High Court, however, did not undertake this exercise and rather affirmed these findings when it did not consider it proper to frame any substantial question of law. It is a settled principle of law that the parties to the suit cannot travel beyond the pleadings. So also the court cannot record any finding on the issues which were not part of the pleadings. In other words, the court has to record the findings only on the issues which are part of the pleadings on which parties are contesting the case. Any finding recorded on an issue divorce the pleadings is without jurisdiction, such is the case. And the third one, (2014) volume 5 SCC 312. There are also the paragraph 15 and 27.
Yes.
This court has consistently held that court cannot go beyond the pleadings of the parties. The parties have to take proper pleadings and establish by adducing evidence that by a particular irregularity or illegality the result of election has materially affected. There can be no dispute to the settled legal proposition that, as a rule, relief not founded on pleadings should not be granted. Thus, a decision of the case should not be based on grounds outside the pleadings of the parties. In the absence of pleadings, evidence, if any, produced by the parties cannot be considered. It is also a settled legal proposition that no party should be permitted to travel beyond its pleadings, and parties are bound to take all necessary and material facts in support of the case set up by them. Pleadings ensure that each side is fully alive to the questions that are likely to be raised, and they may have an opportunity of placing the relevant evidence before the court for its consideration. The issues arise only when a material proposition of fact or law is affirmed by one party and denied by the other party.
That is the principle of
That
law.
is the principle.
So we did not go to para 27. It is relating to election dispute. So let us forget it.
There also some new evidence had come. The Honorable Supreme Court said that even if it has come, it cannot be taken into consideration.
Even if, for that matter, even if there is an admission, Suppose since the parties have not joined issues on that,
Yes.
if there is certain admission that I am son of such and such, I am daughter of such, suppose there is such
Yes.
admission. If the parties do not join issue, that doesn't crystallize into a judgment on that issue. Do we need to go to this Gujarat High Court judgment?
No,
From
no,
an
no,
extent? We can forget about it
Yes, yes.
because it is you are referring to the settled proposition by the Honorable Supreme Court.
These two take judgments.
Sir. देखिए, heard the learned counsels appearing on behalf of the parties. This appeal has been filed against the judgment and decree dated 13/9/2015 within bracket decree sealed and signed on 8/10/2015 entitled appeal number 40 of 1998 passed by the District Judge Mansare Kela, Kharsawa, wherein the appeal has been dismissed. The plaintiff was the appellant before the first appellate court. The trial court judgment was passed by judgment and decree dated 29/8/1998, decree sealed and signed on 10/9/1998, passed in title suit number 40 of 1994, whereby the trial court held that the suit property, which was gully, whereby the suit was decreed partially and the defendant was permanently injuncted and restrained from interfering with the plaintiff's right to use the suit land as gully and rasta. The learned counsel, this appeal has been admitted for hearing by order dated 13/5/2024 after framing the following substantial question. The learned counsel for the appellant has submitted that the suit property, which was a gully, was declared to be partly, which was in plot number 346 within bracket A, was declared to be partly carved out from old plot number 460 within bracket 0.00.30 hectare equivalent to 3/4 decimal. 3/4 decimal, and partly carved out from old plot number 461 within bracket 0.00.2011. Okay, for 0.20 hectare equivalent to half decimal. And it was the plaintiff had purchased the plot number 461 and plot number 460 was belonging to the plaintiff, and therefore the gully was fit to be declared. And therefore the right, title, interest and possession of the plaintiff ought to have been declared with respect to the gully. The learned counsel has referred to Exhibit 3.
3.
Exhibit 3, and which is dated which is a registered sale deed and has submitted that by virtue of the sale deed, the property in plot number 345A, area 0.0080 hectare, comma plot number 345B, area 0.0020 hectare, and plot number 345C, area 0.01.20 hectare, was purchased by the plaintiff. He submits that plot number 460 was equivalent to new plot number 346A, and plot number 461 was equivalent to new plot number 345 within bracket A within bracket B within bracket C. The learned counsel submits that on the strength of Exhibit 3, it was clear that plot number 460 and 461 belonged to the plaintiff, and therefore the gully being spread in plot number 346A and also in plot number 345A has no relevance in view of the fact that old plot number 460 and old plot number 461 belonged to the plaintiff. Correct? The learned counsel appearing on behalf of the respondents has opposed the prayer and has submitted that the plaint of the plaintiff revealed that the plaintiff claimed that the suit property, that is gully, was situated only in plot number 460. It was never the case of the plaintiff that it was spread over plot number 461. He submits that no reference was made in connection with he submits that, however, upon appreciation of facts, the learned courts have held that gully was located in plot number 460, old plot number 460 and new plot number 346 within bracket A, and also in plot number 461, new plot number 345 within bracket A. And plot number 461 consisted of 345B and 345C also. The learned counsel submits that the courts cannot go beyond the pleadings, and in view of specific pleading that the property was, that the suit property, that is gully, was located in old plot number 460 and corresponding new plot number 346 small a, there was no scope for the learned trial court to declare the right, title and interest of the plaintiff with respect to gully, which was used jointly by the plaintiff as well as the defendants and other persons, particularly the inmates of one complex which was used for the employees of the bank. Yahi hai kahani to?
Yes,
Story. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2015, bracket close 9, SCC 755, para 39. Then bracket 2018, bracket close 11, SCC 652, para 26. Then bracket 2014, bracket close 5, SCC 312, para 15. And has submitted that the principle of law that parties cannot go beyond the pleading is in turn based on sound principles, inasmuch as if such a plea is taken, the other party would have an opportunity to lead evidence, to rebut the same and lead evidence. The learned counsel has submitted that the evidence of the respective parties has to be seen within the pleadings exchanged and issue raised in the suit. He has also submitted that in view of the specific plea of the plaintiff, as with regard to plot number 460, a specific issue was also framed. That was issue number 7. That is whether the present suit land is not part and parcel of old plot number 460. He has also submitted that in absence of any pleading by referring to plot number 461, neither any issue was framed nor any such finding could have been recorded. He has submitted that the substantial question of law be answered in favor of the respondents and against the applicant. After hearing the learned counsel appearing on behalf of the parties and considering the nature of substantial question of law as framed, this court has gone through the plaint and the written statement filed on behalf of the parties. During the course of arguments, the learned counsel for the appellant has not been able to show any plea so as to show any admission on the part of the parties that the plot number 461 in entirety, the plot number 461 was involved in the suit property or it belonged to the plaintiff. Upon going through the plaint of the title suit, this court finds that the specific case of the plaintiff was that the suit property is within plot number 460 of Khata number 515 of Survey of 1964, containing an area of 0.57 decimal, recorded as Sanjukt Dakhal of the recorded owners and the plaintiffs, within bracket para number 8. It was further case of the plaintiff in paragraph number 11 that a small portion measuring 0.011 by 4 decimal equivalent to 0.0050 hectare which was a portion of old plot number 460 was kept as gully, was recorded wrongly in the name of the defendant as plot number 346 within bracket 8. The schedule of the property also referred to only plot number 460 old, and there was only plot number 460 within bracket only plot number 460 old and corresponding only plot number 460 old. Thus, the entire case of the plaintiff was based on the pleading that the suit property was located in a portion of plot number 460 old. So far as the written statement is concerned, the defendants had denied the claim of the plaintiff that the suit land is part and parcel of plot number 460 of khata number 515 and are total, and it has also been stated that the plaintiff never used the gully and the suit land at any point of time, and it was an exclusive possession and it exclusively belonged to the defendant, and that the suit land was not a part and parcel of plot number 60, but the same was a part and parcel of RS plot number 462. However, the learned trial court, after considering the materials on record, came to a definite finding. The learned trial court framed the various or as many as 11 issues which are as under. This court further finds that since the learned trial court, since the specific case of the plaintiff was that the suit land is situated in old plot number 460, a specific issue-wide issue number 7 was also framed. The learned trial court, after considering the materials on record, held that the gully was situated in plot number 346 within bracket A and was the and that plot number 346 within bracket A was partly carved out from old plot number 460 and partly carved out from old plot number 461. And therefore, the learned trial court held that the suit land was not part and parcel of old plot number 460 alone, and accordingly held that the gully, the suit land, was not the did not exclusively belong to the plaintiff, and therefore the plaintiff did not have exclusive right over the gully and rasta. However, at the same time, and also recorded that no part of the new plot number 346 within bracket A was carved out from old plot number 462. Accordingly, the suit was partially decreed and the defendant was permanently injuncted and restrained from interfering the plaintiff from using the suit land as gully and rasta. This court finds that the learned trial court has decided the case within the frame of the suit and by detailed reasoned order has rejected the plea of the plaintiff that the suit land, that is gully and rasta, was exclusively situated in plot number 460, old plot number 460. The learned trial court also did not accept the plea of the defendant that the gully and rasta was part of old plot number 462. Rather, it recorded that the gully and rasta was part of old plot number 460 and 461. This court also finds that the learned appellate court also discussed the materials on record and gave concurrent findings and dismissed the suit. This court is of the view that when there was a specific that there was no admission in the pleadings of the respective parties with respect to the right, title, interest and possession of the plaintiff over the suit property. And so far as and so far as the Exhibit 3 is concerned, though the same revealed that that certain portion of plot number 345A, 345B and 345C was purchased by the plaintiff, but as per the findings, old plot number 461 was equivalent to plot number 345A, 345B, 345C. But it is not clear as to whether the entire area of old plot number 461 was purchased by the plaintiff. Further, such plea which has been raised by the plaintiff during the course of argument for the purposes of consideration of substantial question of law as framed is beyond the pleadings of the respective parties, as it was a specific case of the plaintiff that the property was only in old plot number 460, and it was never the case of the plaintiff that it also fell in plot number 461. The learned counsel for the respondents have rightly relied upon the aforesaid judgments, wherein it has been held that in case that unless the pleadings are amended, it is not open to the court to go beyond the frame of the suit. वो paragraph quoted रहेगा, ठीक है? This court, considering the aforesaid facts and circumstances and having gone through the respective pleadings and the material which has been placed by the learned counsel for the appellant, the aforesaid substantial question of law is answered against the appellant and in favor of the respondents, and this court finds that the learned courts have not committed any error in not declaring the right, title and interest of the plaintiff over the suit property, and there is no admission in the pleading and in evidence that the suit land was the ancestral property of the plaintiffs/dependents. Accordingly, the substantial question of law as framed, having been answered in favor of the respondents and against the appellant, this appeal is hereby dismissed.
For orders item 4, second appeal 360 of 2016.
For substitution of legal rights of the respondent of the parties in file. Notices were issued which has been duly served.
How much is the delay? How much is the delay? There is a substitution petition also. It has been substituted.
No, yes.
पहले substitution होगा तब ना limitation करना होगा. Substitution किसका है ये?
Respondent number 1.
Respond number 1. Notice was issued.
Your words. And duly served.
अच्छा substitution का ही limitation. आप किनकी तरफ से हैं?
And for the respondent.
Any objection to limitation and substitution? No, no objection. And the other IA is for condonation of delay in filing the substitution.
Yes.
दूसरा का IA नंबर कौन सा है?
17,
17.
25.
Legal hearing. ऊपर नीचे, ठीक है? ऐसे नहीं लगाना। देखिए, IA number 13885 of 2024 with IA number 17 of 2025 in second appeal number 360 of 2016. The learned counsel appearing on behalf of the appellants has submitted that IA number 13885 of 2024 has been filed for substitution of the legal heirs of the deceased respondent number 1 who has expired in the year 2020 during the pendency of the present appeal. The legal heirs and successors of the respondent number 1 has been mentioned in paragraph 4 of the interlocutory application. He has further submitted that IA number 17 of 25 has been filed seeking condonation of delay in filing the substitution petition. The learned counsel has also submitted that
So what is the amendment application? They have not filed from the recall for they have not filed. Since 4 years have already been passed.
अबेटमेंट सेटिंग असाइड फाइल नहीं किया
17.
17 में लिखे हैं बताइए सेटिंग असाइड अबेटमेंट अबेटमेंट का प्रेयर तो आपको देना पड़ेगा ना बीच में कोविड-19 भी था कुछ तो एक तो पिटीशन तो फाइल करना ही पड़ेगा ना
कर देना
छोड़ दीजिए फिर इसको ठीक है सिंपलिसिटी रह जाएगी कब रखने बताइए
आपके बोलिए
counsel for the appellant seeks adjournment. Post on 19th को रखते 19th March. Post on 19th March.
अपीयरेंस दे दीजिएगा अपना
बीच में कोविड पीरियड भी था चेक करेंगे
जी
उसमें तो
सुप्रीम कोर्ट का है
देख लीजिएगा नेट में जाइएगा आपको मिलेगा कौन सा पीरियड है कोविड में वो आप पिटीशन में डाल दीजिएगा तो बस
Item 5, second appeal 538 of 2016.
There is one idea, my lord, idea number 264G
for
for transposing defendant number, respondent number 9,
2640 of
2025.
for the order 1 rule 10
No.
you were the
Defendant in this suit.
this is defendant's appeal
Yes, it is defendant's appeal, but this defendant was not a party in the appeal before the court of appeal. And
before the,
he is
before the
also
first appellate court you were not party
were party as a respondent, not as an appellant.
then
Now, all the defendants are aggrieved by the judgment.
you were pro forma defendant
No, we were not pro forma, but they
is
are
there any conflict of interest between two defendants
no
is there any conflict of interest between
plaintiff and them. So,
this respondent number 16
yes.
wants the transposition as appellant what do you say you want to respond to this
I am only for respondent number 19 minus. So my position is similar to his because we were also the defendant. The contesting plaintiff has not appeared. My last order I was
बिना बिना appearance के ऐसे ऑर्डर नहीं करेंगे ठीक है
because I was for respondent number 19.
ये क्या चल रहा है
The
आपका
notice
second appeal has been admitted
Not
No
yet
mileage.
2016 से क्या चल रहा है? 10 साल होने को आया,
Not yet eliminated.
2-3 बार DFD हो चुका है,
नहीं,
नहीं हुआ है। चलिए खुशी की बात है, सब लोग मर गए कि बचे हुए हैं?
नहीं वो substitution है।
कुछ substitution हुआ है, but
क्यों ही आप लोग ये सब फाइल करते हैं? You shouldn't have filed it also.
Main contesting के लिए- main contesting
ऐसा है कि ये सब आईए का कोई फायदा नहीं है ट्रांसपोर्टेशन का, ठीक है?
party
अब बस अगर सब्सटेंशियल क्वेश्चन ऑफ लॉ ही नहीं होगा तो बात खत्म है, फिर आप बहस करिए सब्सटेंशियल क्वेश्चन। 2016 में हमको नोटिस नहीं करना, यू आर्ग्यू ऑन सब्सटेंशियल क्वेश्चन। क्या फायदा है बताइए?
suit was filed. Suit was filed for declaration of title recovery for this.
बहुत सारे लोगों के अगेंस्ट में अबेट भी कर गया है, आपको मालूम है?
last order में
अपील अबेटेड अगेंस्ट रिस्पॉन्ड नंबर 18 बाय ऑर्डर डेटेड 14/8/24।
देखिए कर दिया सब।
वही हम सोच रहे थे 2016 का कोई मरा नहीं, ऐसा
Last
हो
order
नहीं
में
सकता।
ही लाया हुआ अभी था। Last order में कुछ ये था कि कुछ सर्विस रिपोर्ट में जब हुआ था तो पता चला था।
लास्ट ऑर्डर में ये 18 मर गए हैं, ये ऑर्डर डेटेड 4/8/24 को आया है और सर्विस रिपोर्ट इज डेटेड 8/3/23।
Yes, yes. उसका substitution
क्या करें हम बताइए? ये ट्रांसपोजिशन ये सब नहीं करेंगे आप, सब्सटेंशियल क्वेश्चन ऑफ लॉ में से दे आएंगे।
Transposition इसलिए कर रहा हूँ ना कि
भाई सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम होगा तो करेंगे,
जी,
तब आइए आपका कंसीडर करेंगे, सोचेंगे क्या करना है।
these defendants are aboriginal member of scheduled tribe.
ये कोई रीजन है ट्रांसपोजिशन का?
No, no, I am not saying so.
हाँ, then?
My submission is
नहीं आपका तो, आपको बहस करना है तो अबेटमेंट इज ऑलरेडी देयर, आप सब्सटेंशियल क्वेश्चन ऑफ लॉ पे बहस करिए, अभी ऐसा ट्रांसपोजिशन का ऑर्डर नहीं करेंगे। अगर सब्सटेंशियल क्वेश्चन ऑफ लॉ अगर मान लीजिए आपका सेकेंड अपील एडमिट हो जाता है तो आईए पर ऑर्डर होगा, जब होगा, अभी से क्यों होगा? क्या है पढ़िए आप, 2016 का सेकेंड अपील पाल पोस्ट के बड़ा किए हुए हैं,
suit was
अगला जनरेशन के लिए। जनरेशन बदल गया 10 साल में।
जी, suit was filed by the plaintiff declaring
आप रेडी हैं करने के लिए?
कल पर रखिए चाहे तो दूसरे दिन
देखिए, learned counsel for the appellant has submitted that IA number 2640 of 2025 has been filed seeking transposition of respondent number,
नहीं इसमें
transposition of
16
respondent number 16 as one of the appellant. However, he has fairly submitted that the respondent number 16 was never the appellant before the learned first appellate court. The learned counsel for the respondent number
19
has submitted that so far no substantial question of law has been framed.
No, minus that cannot be stated because I am for the defend main contesting. I was also for a defendant only.
Okay.
He
So
also-
I am
Okay.
also, I am also
Just
for-
a moment. इनका submission खाली, the learned counsel for the respondent number 19 is present. The suit has already, the appeal has already abated as against respondent number 18. The
death किया।
एग्जामिन कर लेंगे कि है कि नहीं है कि उसके एयर्स आर ऑलरेडी ऑन रिकॉर्ड। फातिमा बेगम रिस्पॉन्ड नंबर 18 वाइफ ऑफ लेट इजराहुल हसन हक and the respondent number 92
the considering
27 are the heirs.
considering the fact that the matter is pending since 2016, this court is of the view that prior to issuing notice on the aforesaid interlocutory application, it would be better to examine as to whether any substantial question of law is involved in this case for admission. If the substantial question of law is framed and the case is admitted, then the interlocutory application can be considered even at a later point of time. ठीक है? कोई डिले वगैरह तो नहीं है?
डिले हो गया, सब कंफर्म हो
सब कंफर्म। Post on 8th of April for the aforesaid purpose.
Item 6, second appeal 212 of 2023.
Who's for the appellant
The substitution petition.
of
Respondent number, my lord, 128.
one is the information.
Yes.
This information has been given by the respondents.
Yes, my lord. And subsequently, my lord, paras 6 and 4 is the name of the legal heirs of respondent number
This
1.
is not a substitution petition. This IA number 2033 or 25, is it a substitution petition? This is just an information. To inform this court.
Inform this court be substituted in present appeal directed against the judgment.
Right. Substitution petition has to be filed by you.
Yes.
Because there may be so many things. Listen, ऐसा नहीं, ऐसा गलत ऑर्डर मत कराइए.
There was, if Lordship can look at para 1, my lord. And
Who
para
are they with? You are the appellant?
Yes.
You substitute?
My lord. I'll file a fresh.
Substitution ऐसे mechanically थोड़ी हो जाएगा. Learned counsel for the appellant. Praise for time. And submits that through IA number 2033 of 2025. It has been brought on record that respond number 1, 2 and 4 have expired. And the name of legal heirs and successors of the said respondents have also been mentioned in the interlocutory application. He prays for adjournment. आइए क्लोज कर दें. आइए नंबर 2033 और 25 informing about the death of respond number 1, 2 and 4 is accordingly closed. Post on at the request of the appellant, post this case on 8th of April.
For financial disposal item 2, second appeal paper 5 of 2017.
But in this case, Bhai Kumar Misra has to argue this matter, he is out of his decision, therefore I am
Prayer rejected. आपको करना है करिए, नहीं तो अभी डिसमिस पर डिफॉल्ट कर देंगे.
पर्सनल डिफिकल्टी
कोई पर्सनल डिफिकल्टी नहीं है, कोई एडवांस नोटिस नहीं है. पिछली बार नोबडी एपियस था.
हाँ
लास्ट टाइम ही डिसमिस कर देना चाहिए था, लेकिन लास्ट टाइम आप लोग एब्सटेन किए हुए थे कोर्ट. आज पर्सनल लेवल पर कोर्ट एब्सटेन है, नहीं होगा. मैं नहीं ऐसे एडजर्न करेंगे. कोई पर्सनल लेवल नहीं, आप कोई एडवांस नोटिस नहीं, हम नहीं एडजर्न करेंगे ऐसे. दैट इज नॉट माई सिस्टम ऑफ वर्क. होली के बाद रखेंगे 10,000 रुपये कॉस्ट करके रखेंगे जरूर. आपको क्या बोलना है? कंसेंट आप पर भी 10,000 रुपए
नहीं
cost
नहीं
लगा।
कंसिडर नहीं तो स्टे है इसमें और स्टे सेवरल एडजर्नमेंट ले चुके हैं
अपोज भी कर रहे हैं।
और लास्ट में इनको 1000 कॉस्ट लेकर के
सब और उसके साथ पर्सनल डिफिकल्टी है जो सीरियस पर्सनल
नहीं नहीं हम जान रहे हैं, लेकिन एडवांस नोटिस क्यों नहीं? आप देखिए आपकी तरह तो तेज हम है नहीं, हमको फाइल पढ़ने में बहुत टाइम लगता
हजूर
है।
हमसे भी अभी उनका जूनियर रिक्वेस्ट किया, मतलब 3:30 बजे की हजूर के सामने
उनका
only
जूनियर
for this purpose
उनका
है
जूनियर भी बिजी हो गया उनके साथ।
नहीं हजूर
ऐसे नहीं हो, इस तरह से मत
खाली
करिए।
इतना सा रिक्वेस्ट है, होली के बाद जो भी दिन रख जाए लोग वो नहीं करेंगे, हम कर देंगे बिकॉज फाइल हमको नहीं था हजूर, नहीं तो हम तैयार होकर कर देते।
चलिए कोई बात नहीं, शुरू करिए। शुरू करिए ना। क्वेश्चन ऑफ
फाइंडिंग ऑफ फैक्ट है हजूर।
हाँ,
द प्रेजेंट
क्वेश्चन ऑफ लॉ बताइए कहाँ है, पढ़िए।
पढ़िए।
ऐसे तो नहीं आप बताने
क्वेश्चन ऑफ लॉ
अभी 10 मिनट बाकी है, 10 मिनट तक बहस
If my
करिए।
lord may kindly see the order dated 21/6/2008.
हाँ देखिए, पढ़िए क्वेश्चन ऑफ
हाँ पूरा अच्छा
क्वेश्चन ऑफ लॉ खाली।
क्वेश्चन ऑफ लॉ whether the genuineness, correctness, existence and execution of the unregistered lease deed dated 8/9/1981 which was proved by PW3 Vinod Mandal, advocate clerk, is doubtful and questionable, and therefore the judgment and degree of eviction passed by both the learned court below is unsustainable in the eye of law. This is one answer. The second one is whether the learned lower appellate court has gravely erred in law by shifting the onus of proving unregistered deed of lease dated 8/9/1989, Exhibit 1 upon the defendant, which is contrary to the well-settled proposition of law that the plaintiff has to stand on his own legs and he cannot derive any benefit from the weakness of the defendant's case. In this case, my lord, if my lord may permit me to read the entire order, my lord, that has been summarized, because the entire case of the plaintiff is.
पढ़िए
पढ़ देते हैं. The plaintiff have filed eviction suit, being eviction suit number 2 of 2011 for eviction of the defendant, which is a residential house on the ground of default and personal necessity. The court below has recorded the finding that relationship of landlord and tenant exists between defendants, and further there is a default in payment and also requirement of personal necessity that has been held in favor of the plaintiff. Accordingly, order of eviction has been passed. Being agreed, the defendant have challenged the same in appeal, being titled Appeal number 32 of 2015. The appellate court has also confirmed the finding recorded by the trial court. Accordingly, the appeal has been dismissed. Thus, there are concurrent findings of both the courts below. Learned counsel for the appellant has challenged the concurrent finding on the ground that the same has been based upon inadmissible piece of evidence, ignoring the relevant piece of evidence. Relationship of landlord and tenant has been established on the ground of unregistered lease agreement, although the same can be used for collateral purpose, but the defendant has disputed the existence of the same. The said unregistered deed of lease has not been proved by any cogent evidence. The prosecution evidence number 1, the petitioner evidence number 1, who has given the oral evidence regarding existence of the lease agreement, was 1 year old on the date of alleged lease agreement. Further, the court has shifted the onus upon the defendant that they were supposed to prove the signature on the lease agreement that the same was not genuine. Both the courts below committed grave mistake by shifting the onus, and on the basis of finding has been recorded regarding existence of the relationship of landlord and tenant in view of the above background. But in this case, defendant's case was that they were since 1932 possessing the said property and residing in the same. Now, on the basis of one unregistered lease deed of 1989, the plaintiff sought the defendant to be evicted from the suit premises on the ground of personal necessity as well as default in payment. Their case was that this lease deed was executed for 11 years.
एक्सपायरी ऑफ लीज का तो कुछ था ही नहीं।
नहीं, एक्सपायरी ऑफ लीज का नहीं था।
नहीं था ना।
हाँ, लीज
टेनेंसी एडमिटेड है।
9 साल नहीं, हम लीज डीड को ये एडमिट नहीं कर रहे हैं, हमारा इंडिपेंडेंट क्लेम ऑफ टाइटल है।
मतलब you denied the relationship of landlord and
tenant. हमारा
there is
इंडिपेंडेंट
no evidence regarding tenancy. What is the finding of fact so far as tenancy is concerned?
आधा घंटा समय मिला तो भाई ऊपर से जो पढ़े उसी
वो
आधार
हम
पर
भी आपके साथ ही पढ़े।
इसलिए हम प्लेस कर रहे हैं कि उतना अब पूरा फाइंडिंग नहीं पढ़े है, पढ़े होते तो जरूर मार्क ही कर देते।
क्योंकि देखिए अगर लैंडलॉर्ड टेनेंट का रिलेशनशिप
अगर रिलेशनशिप हो गया तो हम आउट ऑफ कोर्ट
यू आर एब्सोल्युटली आउट ऑफ कोर्ट। पढ़ लीजिए ऑर्डर, अभी डिसाइड करते हैं।
इसको
नहीं करेंगे आज, लेकिन आप जरा पढ़िए, आप
हम
जरा
इसको
देख
तैयार हो
लीजिए।
जाते हैं जो होली के बाद आप जिस दिन रख दीजिए हम बस कर देंगे।
होली के बाद तो हमको नहीं पता हम जिएंगे कि मरेंगे, अभी हमको क्या ही पता है।
वो तो आज कल पे भी वही चीज
नहीं कल तक हम जिए
नहीं ऐसा मालूम इसलिए इसको अब होली आ गया है
नहीं कल तक का हम गारंटी ले सकते हैं, हम नहीं मरने वाले कल तक, ऐसा नहीं होगा। अगर लैंडलॉर्ड टेनेंट रिलेशनशिप का कॉन्करेंट फाइंडिंग है तो लीज डीड कौन एग्जिबिट किया नहीं किया इसका कोई रेलेवेंस नहीं, सिंपल। गलत बोल रहे हैं
हम देख लेते हैं, हम फैक्ट पढ़े नहीं है जो, इसलिए हम क्या अभी क्या बोले। लेकिन हाँ अगर ये है कि अगर देयर इज अ कंकरेंट फाइंडिंग ओनली ऑन बेस्ड ऑन एविडेंस दैट देयर इज अ लैंडलॉर्ड एंड टेनेंट रिलेशनशिप, तो हमारा केस नहीं बनता है। हमारा कहना है जो फॉर द प्रेजेंट कि इसको होली के बाद आप कोई डेट दे दीजिए। इफ मिस्टर अभय कुमार मिश्रा डजंट कम देन आई विल।
जिस केस को हम वो हमको कोई गारंटी नहीं कि हम जिएंगे कि मरेंगे, तो हम
तो हजूर तो एक एक सेकेंड पे लागू है। अभी तो देखिए हाई कोर्ट में ऐसा घटना घटा, बहस करके निकले और वकील साहब चले गए। तो इसलिए हजूर उस पर तो फिर उस लॉ पे चलेंगे तो फिर कुछ भी हो सकता है, कभी भी हो सकता है। तो इसलिए 4 दिन में भी कुछ नहीं होगा, अब नहीं तो होने के लिए तुरंत होगा। तो सेकंड सब्सटेंशियल क्वेश्चन ऑफ लॉ इस पॉइंट पे है कि ओनर्स वाज शिफ्टेड ऑन डिपेंडेंट, तो उस एस्पेक्ट को भी थोड़ा सा एग्जामिन कर लेते हैं।
डिफॉल्ट कब से कब तक का बताएं?
बोल रहा है कि जब जो मेल टीनेज थे उनके डेथ के बाद शायद लोग पेमेंट दे दीजिए, हम दिखा दें। यहाँ लिखते हैं अनफॉर्चुनेटली परमानंद शर्मा डाइड इन द मंथ ऑफ अगस्त 2010 and thereafter these dependents stopped paying the house rent and thus they have defaulted payment of rent since July 2010. The plaintiff demanded rent on several occasions but the defendant failed to pay and thus they have become defaulter under the provisions of Section 11(1)(d) of the Jharkhand Building Lease Rent and Eviction Control Act herein after double inclusion. Thus the plaintiff have been entitled to realize 2500 as arrears of rent from the defendant from month July 2010. From 2010 से कहते हैं कि वैसे मैनेजमेंट
Karu Mandal is the plaintiff.
Karu Mandal is the great grandfather of the plaintiff.
आपका एडमिशंस है, देख लीजिए.
पूरा तैयार नहीं है जो खाली हम ऊपर से देखने की कोशिश की थी कि अगर हो जाता तो, लेकिन तैयार नहीं हो पाया तो इसलिए हम
1936 में कहता है कुल्फा हमको जमीन मिला हुआ था और 92 तक ये कुछ नहीं करता चला. इवन
हाउस बना के रह रहे हैं.
नहीं 92 तक कहीं नहीं है.
तो आपका प्लेंटिफ क्यों नहीं आया ये सब एग्जिबिट करने के लिए? एडवोकेट क्लर्क से क्यों कर रहा है आप एग्जिबिट? यस, हु इज एडवोकेट क्लर्क? उसको कोई क्रॉस एग्जामिन कर सकता है? बताइए.
क्या गया उधर, चूंकि वो सारा चीज भी किया था.
एडवोकेट साहब पे जमीन इन्वॉल्व है क्या?
वो लीज डीड पे वो चूंकि वो करवाया हुआ था, इसलिए वो बिकॉज इज द एडवोकेट क्लर्क ऑफ द कंसर्न पार्टी.
लीज डीड एग्जीक्यूट करते समय वही था क्या? ऐसा बोला है क्या गवर्नर ने?
हाँ,
हाँ बोलने के पहले सोच लीजिए. देखिए, सेकेंड अपील नंबर 555 of 2017, Mr. Rajiv Nandan Tiwari prays for adjournment by submitting that Mr. कितना नाम बोला? Abhay Kumar Mishra is unable to appear before this court on account of personal difficulty. Counsel for the respondents has opposed the prayer for adjournment and has submitted that the appellant is the tenant over the suit premises and the eviction suit has been decided against the appellant by concurrent findings recorded by both the courts. Since the appellant is seeking adjournment on account of personal grounds of Mr. Abhay Kumar Mishra, the matter is adjourned and is directed to be posted on 17th of March 2024 to be taken up at 2:15, and it is made clear that no further adjournment will be granted.
Okay.